Hey, good morning, everyone. This is a meeting of the Water Quality Control Commission on December 9th. I'm the chair. I'm Bruce Thompson. We've got an agenda, and the first item on the agenda is roll call. So, Ms. Jones, if you would call a roll for Louise.
I will. Good morning, all. Commissioner Zemlik, are you present? Commissioner Bayless,
Present.
Commissioner Brankard,
Present.
Commissioner Barunda. See him. Commissioner Chapman,
Present.
Commissioner Langer.
Present.
Thank you. Commissioner Fry,
Present.
Commissioner McWilliams.
Present.
Thank you. Commissioner Rosatos,
Present.
Commissioner Sloan.
Yo.
Chair Thompson.
Here.
Commissioner Vigil. Commissioner Laney.
Present.
Mr. Chair, you have a quorum.
Great. Thank you very much. And yeah, all right. Second item on the agenda is approval of the agenda. I would entertain a motion to approve the agenda. So moved.
Second.
Okay. I don't think we need to have a roll call vote for this one. So all in favor, say aye.
Aye.
Opposed. Next is approval of the minutes. And they were sent out several days ago.
Chair Thompson, the only thing that I saw that was didn't look right was I don't believe Chair Zemlik was at the meeting. And it says she voted and was present.
Maybe the proposed amendment is that State Engineer Anderson. She was.
I believe she's on the platform.
Yeah.
Yes. And she might have missed roll call, but I believe she voted at some point.
Yes, she did.
Thank you. I'll make those corrections.
Okay. Good catch.
Mr. Chair, on the motion on item 6, says I move to vacate the July 8th hearing. We didn't have a July 8th hearing. I think I moved to vacate the July 8th action to hold a hearing.
Noted. Thank you.
Okay, any other questions? And so again, I would entertain a motion to approve the minutes with the 2 corrections.
This is Commissioner Fry. I move to approve the minutes with amendments.
Second.
Okay. Comments, questions? All in favor, say aye.
Aye.
All right. Thank you. Commissioner Zemlik abstained. Next item on the agenda is public comments. These are comments from the public on general issues. We're not generally accepting comments on agenda items. Is there any member of the public that would like to comment? Please come forward. You need to activate the microphone and state your name. And
Mr. Chairman, members of the committee, can you hear me okay?
3 minutes.
Great. Mr. Chairman, members of the committee, the commission, my name is Matthew Gonzalez. I am the executive director for the Consumer Energy Alliance. I wanted to just provide comments. I provided comments last meeting, but just wanted to reemphasize the need for rural meetings. The majority of the water that is utilized in the state of New Mexico is not utilized in Santa Fe. As I travel the state, I continue to hear from folks around the area, around the different parts of the state, whether it's agriculture, industry. People want to start having more access to these meetings. I do know that there's an online option. I don't think that anything replaces the value of being face-to-face with commissioners and having the opportunity to visit with you and talk with you one-on-one. So I want to reemphasize that. I want to also emphasize the need for a hearing on produced water. I think we need to continue to have that conversation. When that legislation was passed by back in 2019, it was done in a bipartisan manner. I would say many would consider Speaker Egoff to be one of the most progressive members of the legislature at the time. It was passed in a bipartisan manner with a state representative, Rod Montoya. Rod is considered to be one of the most conservative members of the legislature, but they came together understanding that New Mexico really needed to be grappling with these types of challenges. They understood that this would set us up in the future to take advantage of that water, not continue to send it out of state or not do anything with it, continuing to deep inject it. So water scarcity continues to be a problem for the state of New Mexico. So I just want to re-encourage that we should be considering those options. I know that there's a lot of counties that would be happy to host meetings. So if I can work with your commission in any way, shape or fashion, would be happy to help host some of those meetings in some of these rural areas. Make sure that we're hearing from the heart of New Mexico, these people that are the frontline communities every single day. Because I know that they want to be part of that conversation. So if there's any way that we can facilitate some of those things, I'll make sure to leave my information with staff so that they can reach out, but would love to help you guys get out to the rural areas, introduce you. You do a lot of great work, and I don't think that it does us any, I think it does a disservice to the state of New Mexico by just being in Santa Fe and them not knowing all the things that you're all working on. So if we can help facilitate some of that, we'd be happy to do so. Thank you for the time.
Thank you, Mr. Gonzalez. And again, state your name and you have 3 minutes.
Yes, sir. Hear me okay?
Yes. Microphone.
Mr. Chair, Commissioners, my name is Christian Isley. I do state government affairs for Chevron here in New Mexico. I had the great pleasure of working for Chevron for many years in the community of Cuesta in Taos County. They asked me to protect their water rights, so I spent a good long time doing that. I want to give credit to former state engineer Mike Hammond and current state engineer Liz Anderson for reaching a settlement with Cuesta to protect their water rights for future generations. Cuesta, the communities in that area in Taos County, we're hearing throughout the state, are very supportive of produced water reuse because they understand the compact implications. If produced water can be used to meet the compact requirements with Texas on the Rio Grande and Pecos rivers, that will enable communities in northern New Mexico to protect and preserve their access to water rights and fresh water resources. Chevron fully supports these efforts. I can tell you at the Cuesta mine currently, we are treating reclaimed mine water. There is 3 acre-feet of water per day going into the Red River. That's 3 acre-feet per day. That's almost nearly 1,100 acre-feet per year. That is actually going to meet the compact requirements with Texas currently. If we can use reclaimed mine water, why cannot we use produced water? The science is absolutely clear. This water is safe after it's treated. Water treatment technology is evolving very quickly. Other states are moving ahead. California is over 20 years ahead of us on this matter. Texas moving ahead very quickly. I humbly ask you to consider the desires and hopes of these rural communities and consider Mr. Gonzalez's request and offer of help to have hearings in communities like Cuesta. Holding back the science is like holding a broom to the ocean to try to prevent the waves coming in. When there are new petitions coming before this commission, please consider that request. I want to end my statement with a quote from Bob Dylan. Times are changing. Come writers and critics who prophesize with your pen and keep your eyes wide open, the chance won't come again. And don't speak too soon, for the wheel's still in spin. And there's no telling who that it's naming. For the loser now will be later to win. For the times, they are a-changing. Thank you.
Good morning, Mr. Chair, members of the Commission. My name is Jennifer Bradfute, and I'm the Executive Director of the Water Access Treatment and Reuse Alliance. We have had the City of Bloomfield issue a resolution in support of hearing treated produced water rules. We've had the City of Hobbs issue a resolution, and we've now had Lee County issue a resolution. They are very supportive of looking into these water resources. The New Mexico Produced Water Research Consortium has an annual meeting coming forward in January. I recommend that you sign up, come, hear the science. They also hold a monthly webinar. Right now, there's not a high attendance number for that. Sign up, listen to the science. In providing just a summary of the science that they have put together so far, they have compiled something called the NIPTES Plus list, and that happened early on in the Research Consortium science. In 2021, they put together a paper using machine learning to predict produced water volumes. In 2022, they put together a case study and they mapped where produced water could be reused for specific purposes in the Permian Basin. In 2022, 2023, 2024, they came up with 3 different water characterization studies. Produced water in the Permian Basin has largely now been characterized. More recently, they came up with science on non-targeted and targeted analyses. Can you find out what's in the water without a recipe list? Guess what? You no longer have to rely according to science on a frac focus list. They can actually study and map the water, and they come up with the chemical families with almost 100% accuracy. That's 2025 scientific research. You need to hear the science, but to hear the science, you have to attend the events. And that takes a lot of time, especially if your job isn't specialized in produced water research, which I don't think a lot of you, have that dedicated in your job scope. So we'd like to find ways to partner with you to get that science in front of you. Right now, we know of 3-minute increments where we can come and give this information. If there's another forum where we could come and have more time to present the science to you, we would like to do that. Thank you so much.
Is there anybody else in person? Is there anybody online that would like to make public comments?
Mr. Chair, no one has indicated online that they would like to make a comment.
Thank you.
You're welcome.
Okay, let's move on. Agenda item number 5 is WQCC 2574R. It's proposed amendments to the surface water standards. So I believe NMED is going to make a presentation. And Ms. Lemon, be sure to introduce your collaborators.
Good morning, Chair Thompson and members of the Commission. My name is Brecken Scott, Assistant General Counsel for the New Mexico Environment Department. And I'm joined today by Crystal Weatherly, who's also an Assistant General Counsel for the New Mexico Environment Department. And with us today is Shelley Lemon, Bureau Chief of the Surface Water Quality Bureau. It is a privilege to be here today to represent the Surface Water Quality Bureau of the Water Protection Division of the department. We're before you today on the department's petition, which proposes rules to establish a comprehensive state permitting program for discharges to surface waters in New Mexico and to request a hearing. The department proposes amendments to 20.6.2 NMAC and a new rule at 20.6.5 NMAC. This matter is docketed as WQCC 25-74R. The Surface Water Quality State Permitting Program has been years in the making, and the proposed rules are the culmination of hard work by the department and collaboration with third-party stakeholders. Between 2022 and 2024, the New Mexico legislature appropriated funds to support NMED's development of a state permitting program for surface waters. In the fall of 2024, NMED convened a Surface Water Advisory Panel, or the SWAP, to provide input on program development and draft rules. The SWAP was made up of representatives from tribal and local governments, industry, including from the oil and gas, mining, and construction sectors, agriculture, environmental groups, water delivery and control, meaning irrigation districts and flood control organizations, state and federal agencies, federal facilities, and watershed and wetland restoration professionals. The SWAP met 6 times, and the department compiled a final report of SWAP recommendations to guide legislative development, program structure, and implementation strategies. As you know, in the 2025 regular session, the New Mexico legislature passed Senate Bill 21. Governor Lujan Grisham signed Senate Bill 21 into law on April 8th, 2025, and it became effective June 20th, 2025. SB 21 amended the New Mexico Water Quality Act and enacted a new law, the New Mexico Pollutant Discharge Elimination System Act. Through the combined bill, the legislature authorized the WQCC to adopt rules establishing a state permitting program for discharges to surface waters of the state under the Water Quality Act, and also to adopt rules for discharges to waters of the United States under the NMIPD's primacy program. Together, these two proposed rules provide for a comprehensive permitting program with statewide application and provide maximum protection to New Mexico's surface waters. The bill included authorization for New Mexico to pursue primacy, meaning its application to EPA to administer EPA's NMIPD's permitting program. Applying for primacy involves many requirements. The proposed draft rules include a proposed new part to the NMAC for NMIPD's administration and have been initially reviewed by EPA. NMED will continue to collaborate with EPA on the draft rules in the coming months. Since Senate Bill 21's passage, the Department's Surface Water Quality Bureau has continued to engage with New Mexico's nation's tribes and pueblos, the public, and stakeholders. The Bureau released a draft version of the rules in May to tribal environmental directors, and at the same time, released the draft version of the rules to SWAP members. At the end of August, the Bureau posted a public review draft of the rules, soliciting public input for a 60-day period. The Bureau held 3 informational meetings about the draft rules in September as well. NMED received over 50 sets of comments. NMED incorporated these public comments received, and the draft rules attached to its petition as attachment 2. The Bureau continues to welcome meeting requests and input from the public and stakeholders, and has planned continued tribal engagement this month and in February of 2026. The proposed rules are critical to protecting surface waters in New Mexico. Ms. Lemon will now provide a brief statement to say more about the state permitting program for discharges to surface waters.
Good morning, Chair Thompson and Commissioners. My name is Shelley Lemon, and I am the Surface Water Quality Bureau Chief at NMED. As Ms. Scott said, I'd like to provide a brief overview and summary of the surface water quality permitting regulations the department is proposing. To protect our waters, including state waters not covered by the Federal Clean Water Act, New Mexico is developing a state permitting program to ensure clean water for drinking, recreational, agricultural, cultural, and other uses. The result is a new rule in 20.6.5 NMAC for the New Mexico Pollutant Discharge Elimination System, or NMIPD's program, which implements the NMIPD's Act from Senate Bill 21 and the federal NMIPD's program in New Mexico. It applies to the discharges of pollutants from a point source to a water of the U.S. Currently, there are only 3 states that do not have NMIPD's primacy. They include New Hampshire and Massachusetts in the Northeast, and New Mexico here in the Southwest. New Mexico is planning to request delegation for all 5 NMIPD's program components, which include municipal and industrial discharges, general permits, federal facilities, pre-treatment, and biosolids. The department is also proposing amendments to 20.6.2 NMAC, the Ground and Surface Water Protection Regulations, to implement the Water Quality Act amendments from Senate Bill 21 related to a state-led surface water permitting program. These rules apply to point source discharges as well as discharges of dredged and fill material to surface waters of the state. The intent of the combined regulations is to protect surface waters of the state, including waters of the U.S., using practical and common sense approaches to ensure clean water for all uses and give New Mexico the ability to protect water quality regardless of what's happening at the federal level. The program will not apply to discharges to tribal waters, but the department will be responsive to tribal concerns and ensure that the permitted discharges do not adversely affect tribal water quality programs. So as Ms. Scott alluded to, the department has done a lot over the past couple of years to prepare these rules for your review and adoption or consideration. Last year, from August to October, we convened the Surface Water Advisory Panel to inform Senate Bill 21, as well as the subsequent regulations for a surface water quality permitting program. In May of this year, we provided the draft permitting rules to the SWAP and to tribal environmental directors for preview. And then we released the public review draft on August 29th, 2025 for a public review and comment period of 60 days. In October 28th, the department closed the public review and comment period and incorporated comments that we received into the proposed rules that we have before you. The culminating result is that 20.6.5 NMAC is patterned from existing regulations under 20.6.2 NMAC and includes some unique components specific to the NIPD's program and EPA requirements under the Code of Federal Regulations. As I mentioned previously, the rule is designed to regulate point source discharges of pollutants to waters of the U.S., and the exemptions listed in 20.6.5 NMAC are consistent with the Clean Water Act and Senate Bill 21 exemptions. The proposed regulations include standards, requirements, and processes to issue, renew, modify, deny, and terminate both individual permits and general permits, as well as general permit coverage, including rules that are necessary and appropriate to obtain and sustain authorization from the regional EPA administrator. In the public notice and participation section, the department included notification to governments of affected Indian nations, tribes, and pueblos. And in the public hearing section, the secretary will hold a public hearing if a nation, tribe, or pueblo government requests a hearing. The department also included sections for Water Quality Control Commission review of the secretary's decisions, judicial review of commission decisions, and enforcement. In 20.6.2 NMAC, the rule is patterned from existing regulations for groundwater discharge permits. This rule covers the state surface water quality permitting program under the authority of the New Mexico Water Quality Act and regulates discharges of pollutants into surface waters of the state that are not protected by the Clean Water Act. Similar to the NMIPD's rule, the exemptions listed in section 2303 are consistent with the Clean Water Act and Senate Bill 21 exemptions. The department added or amended 35 definitions in the proposed rules. Many of the proposed definitions are from Senate Bill 21, while others are necessary to interpret the rule and implement the permitting program. The proposed regulations include standards, requirements, and processes to issue, renew, modify, deny, and terminate individual permits, and general permit coverage, including various permit conditions and requirements for all surface water discharges, requirements for only point source discharges, and requirements for discharges of dredged and fill material, as well as compensatory mitigation when there are unavoidable impacts to aquatic resources that must be remedied. The department also included provisions for emergency permits for discharges of dredged or fill material if harm to life or severe loss of physical property is likely to occur before a general permit could be issued or modified under normal procedures. Similar to 20.6.5 NMAC, in the public notice and participation section, the department included notification to governments of affected Indian nations, tribes, and pueblos. And in the public hearing section, the secretary will hold a public hearing if a nation, tribe, or pueblo government requests a public hearing. The department also included sections for the Water Quality Control Commission's review of secretary's decisions and judicial review of commission decisions similar to existing groundwater permitting regulations. And finally, both sets of rules include permit fees. The department has proposed both permit application fees and permit annual fees to distribute the revenue evenly across different fiscal years. Fees for general permits were set as flat fees, and the proposed fees are estimated to cover 100% of the cost of the permitting program. However, the fees may be adjusted based on the legislative session and legislative appropriations to support the program. I'd like to turn back to Ms. Scott to wrap up.
Thank you, Ms. Lemon. The Water Quality Control Commission is authorized under Section 74-6-4R of the New Mexico Water Quality Act to adopt the proposed rule amendments to 20.6.2 NMAC and the new rule at 20.6.5 NMAC. In support of its petition, the department has attached as Attachment 1 a statement of reasons supporting the Commission's adoption of the proposed rules. The department also included a request for a rulemaking hearing in June or July of 2026 for a time period of 10 consecutive days. The department offers the dates of June 8th, 2026 through Friday, June 12th, 2026, followed by Monday, June 15th through Thursday, June 18th, in optimism that the parties can complete the hearing process in 9 days and ahead of the Juneteenth holiday. The department also requested that the commission appoint a hearing officer for this matter. On behalf of the department, we thank commissioners for your time and consideration of the department's petition. The department respectfully requests the commission grant this request for hearing. We're available and happy to answer any questions you have. Thank you.
Thank you. Questions and comments? Mr. Brinkhoff.
Thank you, Mr. Chair. Thank you for the presentation. This is one massive rulemaking. What are the benefits of trying to do this all in one rulemaking?
Mr. Chair and Commissioner, I see the benefits of doing a combined rulemaking to ensure that the rules are consistent across the two different regulatory schemes. We have the Clean Water Act framework on one hand and the Water Quality Act framework on the other. And we want to make sure that we're not developing two separate programs that have different requirements, and the regulated community is confused about how to apply or which rules apply to what. So a combined rulemaking allows us to ensure that we're creating a comprehensive, thorough, unified set of rules for this permitting program.
In your meetings that you've had in outreach, are there any particular areas that you see as being controversial that you will get significant feedback, or the commission will get significant feedback on?
Mr. Chair and Commissioner, the fees are definitely something that is up for debate and controversial. I think the scope of the program and how far are we going to have regulatory reach and require permits. The department is working on a mapping tool that will help with those jurisdictional determinations. So somebody can look at the map and decide if they want to apply for a permit or if they should apply for a permit. So we're trying to create some tools and guidance that will help with those questions, but the rules come first. And so I think probably those are the two things: how, you know, the dredge and fill program, which is a state program. We're not trying to assume the federal 404 dredge and fill program. We're trying to implement a state program for dredge and fill discharges as the Clean Water Act gets scaled back. So that's probably going to be an area of a lot of debate.
Obviously, the federal government is in the process of scaling back their surface water permitting. Does that impact this rulemaking, or can we just simply go ahead with how we're doing this? Or will we be forced to come back again and address it after they've done something?
Mr. Chair and Commissioner, we are establishing these rules so we don't have to continue to go back and forth with the federal government and have that uncertainty of the expansion or contraction of the Clean Water Act. So these rules will establish a state program that will be consistent whether or not that Clean Water Act is expanding or contracting. It will just apply to different, either a federal regulation or a state regulation, if that makes sense. We're trying to create consistency so that we can protect our waters as there's uncertainty at the federal level.
So is the idea that with you have this NMPDS program that will mirror the federal jurisdiction, right? And then a state permitting program. The federal jurisdiction declines, the NMPDS jurisdiction will decline, but the state program will increase its jurisdiction.
Chair Thompson and Commissioner Brankard, I wanted to add, and I think this will help answer your question. There is, we are in the rule proposals adopting some of the federal regulations, which can change. And so we are utilizing a prospective rule adoption so that as those federal regulations change, the rules will automatically fall in line with them. And to answer your question, your most immediate question, yes, if the say the definition of WOTUS changes, then the state program will cover the waters that the federal program are dropping off, if that helps answer.
And then I guess finally, I looked once again at Senate Bill 21. It makes numerous changes to the Water Quality Act, but I get the sense that not all of them are in this rulemaking. Is that correct?
That is correct. Some of those changes apply more to our groundwater program, and those will be for a future rulemaking.
Okay, so the groundwater program will come in with a separate rulemaking to cover the other parts of Senate Bill 21 that are not covered in this.
That's
correct. And then, well, this I guess is a question for groundwater program. But when I read Senate Bill 21, the definition of general permit, it applied to discharge, not surface water discharge. But your rule seems to only apply general permits, surface water.
Mr. Chair and Commissioner, these rules are for surface water discharge permits. So we are focusing on that aspect of the rule. The general permits are for surface water discharge permits.
Okay, not what the act says, but.
And Mr. Chair and Commissioner, and again, maybe the groundwater permitting program will come and adopt general permits. I'm not sure if they will or not.
Thank you.
I'd like to ask the panel. My understanding is that we develop a permit system and then it has to be approved by EPA. Is that correct?
Just in part. So the rules that are proposed under 20.6.5 NMAC, those regulations will need to, EPA's providing their initial review and input now. And then ultimately, after we go through a rulemaking, if those rules are adopted by the commission, then in order to administer that NIPD's permitting program, we'll have to go through a whole application process and approval process just for that component to administer NIPD's.
And that will be 20.6.2?
20.6.5, the new rule.
I understand.
So they EPA will not need to approve 20.6.2.
Okay,
I wanted to add some clarification in that.
please.
Yeah, so EPA won't approve the rule. They can't really approve our rule. But what they can do is approve our program application, which is comprehensive, and it includes what we've done with the Namibi's Act and the rule to create a whole program that complies with the NIPD's primacy. So they're approving the program, not the rule. And if our rule doesn't support the program in a way that they need to approve it, we may be back.
Okay, and that's actually where I'm going is there a chance that they won't approve it? I mean, there's always a chance. I mean, is there a reasonable chance that they won't approve it? Have you been, let me rephrase that. Have you been working with EPA in developing these
Yeah.
regs?
Every step of the way.
And they haven't expressed any heartburn to date.
No heartburn.
Well, they a little, but we've fixed what they were.
Yeah.
Okay. Thank you. Any other questions?
Mr. Chair, I do have one question. You did a great presentation laying out the engagement that you've done throughout the process. I'm wondering, and you mentioned Massachusetts and New Hampshire. Have you consulted with other states that have recently gone through this process?
Mr. Chair and Commissioner, yes, we have. We've also been talking with EPA, as we just noted. We've talked with Idaho, who was the most recent state to go through the primacy application. They went through it in 2018 around. We've talked with Alaska, who was before Idaho. So we've been talking with some states who have recently undergone primacy. Most states, it's been decades long and things have changed. So there aren't that many states to talk to who have gone through it recently. So, but we are in communications at the national level with other states about the program.
Thank you.
Any other questions, Commissioner?
Thank you. Thank you for your presentation. I know the waters of the U.S. falls under EPA, but have you also engaged with the Army Corps of Engineers for the dredge and fill portion?
Mr. Chair and Commissioner, we engage with the Army Corps on the Federal Clean Water Act Section 404 permitting program. We've engaged on dredge and fill permitting, not necessarily these rules, because this is a state rule that will not fall under their jurisdiction. The Corps does not look at anything outside of their jurisdiction, but we coordinate with them frequently under Section 401 for water quality certifications for their federal permits. We anticipate continuing to work with them as we implement a state program and they still administer the federal program. There's going to be a lot of coordination that is required. We have a good relationship with our Albuquerque district and we are in communication with them.
Glad to hear that. I have a couple questions that will probably, be talked about as we go along, but I figured I'd ask them right now since I have the time. You said that this would provide examples that is more inclusive than what the Waters of the U.S. Federal Act includes. Can you give us some of those examples?
Mr. Chair and Commissioner, the surface waters of the state is already defined in 20.6.4. We are proposing to adopt that same definition so it's consistent across regulations. So in that definition, it includes things like intermittent and ephemeral waters, playa lakes, other types of wetlands. So it's pretty broad compared to the proposed new federal definition.
Yes, I would agree because they're definitely scaling back.
And then
Go
another
ahead.
point I would like to make is just that definition for our water quality standards has been in existence for a while. So it's not anything new. We're not trying to expand or add anything. The whole idea of Senate Bill 21 was to maintain the, I don't want to say status quo, but make, 50 years of regulations under the Clean Water Act have proven effective. We're trying to maintain that as the federal regulations get scaled back. So we're trying to put stop gaps with state regulations to maintain that level of protection that has existed for over 50 years.
Agreed. So if an individual or an entity has a federal permit, will they have to have a state permit as well, or is there? I thought I saw there was exemption for that. I just wanted to clarify.
Mr. Chair and Commissioner, yes, there is an exemption. If the federal permit or other state permit covers those water quality requirements, then they will be exempt from a surface water discharge permit.
And I think my last one is the exemptions. C provides an exemption. The exemption in B shall not apply for discharges. And it goes on to say if a new activity brings the surface water into the state into farming production, where an area of the surface water has not previously been used for farming. Under the federal act, I believe their date that they have established was 85. I could be slightly wrong. Will this become effective once the rule gets through rulemaking, and so any farms thereafter would not be exempt? I just wanted to get some clarity there. Sorry, I'll provide the section was 20.6.2.2303, and then it's C, and it says they shall not apply for a discharge resulting in, or the exemption provided in subsection B of this section shall not apply if the discharge resulting in the activities contains toxic pollution set forth by the commission, or if it brings a new surface water into the state into farming production where the area of the surface water has not previously been used for farming.
Mr. Chair, Commissioner, what are you asking if?
So my understanding is that at least on the federal side, there was like a date that became effective. So like a grandfathered in clause, and I could have misinterpreted this because I only loosely read through the federal act to kind of compare the two. And that's what I was hoping to get clarification on, is if you could explain this exemption and if there was like an effective date to it.
My understanding is that it's not a new exemption.
No, I
So
agree.
in the Federal Clean Water Act, it might reference a really old date. So we're not changing anything. We're just, bringing in what already is there, and it won't have a new effective date. It's yeah, whatever's been in effect for probably like 40 something years, 50 years, 40 years, 40 something years.
Thank you.
Just to be super clear, should the commission approve to adopt these regulations, they would become effective, all of them, all of the exemptions, everything that you had adopted. All the regulations would become effective 30 days from the date we file with state records.
Has your question's been answered? Well, we're going to have 10 days of opportunities for questions like that. I had one question, and Commissioner Laney's question reminded me. There are a number of discharges to bodies of water that are not waters of the United States at present, particularly discharges to playa lakes and things like that. How many new permits do you anticipate will be required under this new proposed rule? Any idea?
Mr. Chair, that is a good question. We're not entirely sure because we don't know the universe. If somebody's not reporting an activity or a discharge to us, we can only postulate. So I don't have a firm answer on that. I can say that, the federal program historically has been around 100 to 125 individual permits and around 3,500 to 5,000 general permit coverages, not general permits. There's a handful of general permits, but 3,500 to 5,000 permittees under those general permits. I would anticipate, with our stormwater program, state program, capturing a couple hundred more potentially of those permits or permit coverages, and same on the dredge and fill side with the general permits, probably in the hundreds, not thousands. Individual permits for dredge and fill are not very numerous. It's like on one hand, the number that we certify every year for the Army Corps. So I'm not anticipating a bunch of individual permits for dredge and fill. I think it will be mostly general permits.
Thank you. Any further questions from the commission? So my understanding is the request today is for us to decide whether or not we want to allow a hearing on this and then to appoint a hearing officer. Is that correct?
Chair Thompson. So I have a question about the way they made their petition. They set dates. Do we not need to allow the hearing officer to set those dates?
Yeah.
Okay.
I think they were suggested dates.
Just proposed dates.
So what's the pleasure of the commission? I think we would need a motion to accept this. Is this a petition? We didn't need a motion to accept this petition. Then I would suggest that the commission allow me to appoint a hearing officer who is sitting my right. And she's agreed to do it. So I would entertain a motion. Commissioner Sloan.
I'd move to set a hearing in the matter of proposed amendments to 20.6.2 NMAC and new rule 20.6.5 NMAC and allow the chair to designate the hearing officer for the matter and the date of the hearing.
I'll second.
Okay. Moved and seconded. Further discussion? You ready to vote? All in favor of the motion? Say aye.
Aye.
Aye. Opposed? Opposed? Same? Okay, thank you. Thank you. So moving right along, I assume it's the same panel, is agenda item number 6, which is WQCC 2575, which is standards for interstate, intrastate waters, stream standards.
Good morning again, Chair Thompson and members of the commission. My name is Crystal Weatherly, Assistant General Counsel for the New Mexico Environment Department. I am joined with Bracken Scott, who is also Assistant General Counsel for NMED, and Ms. Shelley Lemon, the Bureau Chief for the Surface Water Quality Bureau. We are before you today to request a hearing on the petition filed by the New Mexico Environment Department's Surface Water Quality Bureau to amend the Commission's regulations at 20.6.4 NMAC, standards for interstate and intrastate surface waters. This matter is docketed as WQCC 2575. As set out in the rulemaking petition, the Federal Clean Water Act and the Commission's regulations require the state to, at least once every 3 years, hold a public hearing for the purpose of reviewing applicable water quality standards and proposing, as appropriate, necessary revisions to those water quality standards. This process is generally known as the triennial review. Following the Commission's approval in March of 2022, the EPA approved the last revisions in January of 2023. And so the department has filed this petition in November of 2025 ahead of January 2026, so within the 3-year period. Pursuant to the state's Water Quality Act, the Commission is the water pollution control agency for the state for all purposes of the Federal Clean Water Act. Under the Federal Clean Water Act, State Water Pollution Control Agency means the state agency designated by the governor having responsibility for enforcing state laws relating to the abatement of pollution. The department is proposing a number of revisions intended to update and clarify the standards as set out in more detail in a draft statement of reasons, which was attachment 1 to the department's petition. In its petition, the Bureau limited changes on the topic of permitting as the separate rulemaking to establish the state permitting program has just been approved. The department initiated communications with tribal leaders and representatives of New Mexico's nations, tribes, and pueblos, seeking input on the proposed amendments, and we are still awaiting any feedback from the nations, tribes, and pueblos. The department has also engaged with stakeholders regarding the proposed rule and amendments, or the proposed rule amendments, excuse me. The department issued a public review draft soliciting comments for a period of 60 days between mid-August and mid-October 2025. The department plans to provide to the public notice of the rulemaking hearing and to complete any other requirements and responsibilities pursuant to the WQCC's rulemaking procedures and any procedural order as may be applicable. The department requests that the Commission set this matter for hearing in September of 2026. We anticipate the hearing to take approximately 4 days, depending on the level of public interest and participation. Due to the relatively complex nature of this proceeding and the anticipated number of parties, the department requests that a hearing officer be appointed. The department further requests that the hearing officer be tasked with developing orders specific to this proceeding, which would set forth timelines and procedures for such things as pre- and post-hearing submittals, pre-filed written testimony, and the public hearing itself. Ms. Lemon will now provide a brief summary to say more about the Surface Water Quality Bureau's proposed rule amendments for the 2026 triennial review.
Good morning, Chair Thompson and Commissioners. Again, my name is Shelley Lemon, and I'm the Bureau Chief of the Surface Water Quality Bureau at the Environment Department. As Ms. Weatherly said, I'd like to provide a brief overview and summary of the Bureau's proposed rule amendments for the 2026 triennial review. The triennial review is a mandatory state-led process under the Clean Water Act, where states and authorized tribes periodically update their water quality standards to reflect new science, address emerging contaminants, and meet the Clean Water Act's fishable, swimmable goals by focusing on designated uses, water quality criteria, and anti-degradation policies. This scheduled review ensures that New Mexico's water quality standards remain current based on scientific progress and new water quality challenges. For this triennial review, the Bureau focused on several important topics. First, the department added language to maintain, restore, and protect wetlands. As you probably know, wetlands are ecologically important and economically valuable to New Mexico. Wetlands provide important wildlife habitat, an essential habitat for endangered and indigenous fish and wildlife. Wetlands also supply stopover, breeding, and feeding grounds for migratory birds. In addition, wetlands provide beneficial services to people and their communities. They play a critical role in supporting agriculture, food production, and tourism in New Mexico, and they act as natural buffers against floods, droughts, and storms, and can help to recharge groundwater reserves. Their unique characteristics and processes contribute to the filtration and purification of water and improve water quality. However, New Mexico has lost at least 35% of its wetlands, and under the federally proposed Waters of the U.S. rule, more than 80% of New Mexico's wetlands will not be protected by the Federal Clean Water Act. Therefore, it is important that the state take action to protect our remaining and valuable wetland resources. The department added language related to wetlands in the definitions in Section 7, the anti-degradation policy and implementation plan in Section 8, and the department proposed a general criterion specific to wetlands and their functions in Section 13. The proposed amendments, combined with the surface water permitting regulations detailed in 20.6.2 NMAC, will ensure our wetland resources continue to provide these valuable services for the citizens of New Mexico. Second, the department evaluated fishable, swimmable goals and identified several water quality standard segments and water bodies that could be amended to primary contact recreation or certain aquatic life uses based on the available data. And finally, the department is proposing to adopt EPA's recommended aquatic life use criteria for perfluorooctanoic acid, or PFOA, and I shouldn't have written it out. Perfluorooctane sulfonate, PFOS. Both PFOA and PFOS belong to per and polyfluorinated substances, or PFAS. I like the acronyms a lot better. They roll off the tongue a lot easier. But this group of chemicals are considered emerging contaminants. And according to EPA, the mechanisms underpinning the toxicity of these chemicals to aquatic organisms is an active and ongoing area of research. But because of the potential concern and risk posed to aquatic life from these contaminants, EPA published the recommended aquatic life criteria for PFOA and PFOS in October of 2024. These criteria reflect the latest scientific knowledge regarding the effects of PFOA and PFOS on freshwater organisms, and the department's proposed amendments include EPA's recommended acute and chronic criteria, which contain chronic criteria expressed as tissue-based concentrations to protect aquatic life from bioaccumulation of these contaminants. The department is recommending these criteria to protect against the harmful effects of PFOA and PFOS on aquatic life. I would like to turn back to Ms. Weatherly to wrap up.
Thank you, Ms. Lemon. So on behalf of the department, we'd like to thank you all for your time and consideration of our petition. The department respectfully requests that the commission grant its request for a hearing, and we're available to answer any questions you may have.
Questions from the commission? Commissioner Brancard.
I think I read in your petition that you're requesting that the commission limit the hearing to the department's proposal, correct? And the reason I'm asking is that in the past, I don't know if we did it the last time, I wasn't around the last, but in the distant past, triennial review allowed a process for other parties to submit proposed changes to the standards. And I sense from your application that you just want us to hear your proposal. And I don't know if that's an EPA requirement or.
I don't have it right in front of me, but I think that the thinking that the department had was that as long as it's a logical outgrowth of the proposal, I think there was a question about public notice and if there are changes presented that weren't part of that notice process. I think was.
Or I think that's my understanding of how it's typically happened in the past, is that you limit the sections that are considered to those that have been noticed.
Right. I mean, but in the way back times, we allowed a process for parties to follow on the department's petition with their own proposed changes and then did notice of the whole thing. Okay. I don't know that we have to do that. I don't say, I mean, I went through the EPA regs. I didn't sense that that was a requirement in EPA regs, but that seemed to be the way way back when turned triennial reviews into this monstrous rulemaking proceeding.
I think that we're on the same page. I think that was something that we had considered. We have also talked about, and this is something we would discuss with our hearing officer, having a schedule that would allow for those proposals to happen in plenty of time. And part of the reason is that we're asking for such a hearing this almost a year from now to allow for some of those changes. Am I misspeaking?
Nope.
Okay.
I think specifically also in the last triennial, for example, red line proposals were due 120 days ahead of the hearing, which is about 4 months. Notice requirements are typically about 60 days.
Yeah, if I might, actually, on the agenda, our next agenda item is an excellent example of a proposed change to the surface water standards that might have been brought up in a triennial review, but the petitioner chose to bring it now. We had a similar matter brought by panel, I think, some months ago. So it's not necessarily something the Bureau would have proposed. I don't know if they would have done that, UAA, but the lab, or Sandia, National Technology and Engineering Solutions, went ahead and did the UAA. And they'll be asking you very shortly to base a decision on that. And that's just sort of one thing that might have been brought up in a triennial review, but you're going to handle it today.
Right. I'm just wondering whether we're going to do that two-step process again.
I think
seemed
that
in
makes
the application that the department didn't want to do that two-step process. So that's why I was bringing it up.
No, I think it makes sense. And I think the only critical question then is, what is the deadline for proposals like this one?
And I think the department would just ask to, or want to keep in mind of just keeping a reasonable scope for that triennial and not let it become week.
Monstrous.
Monstrous. Good word.
Other questions? I have one. In the previous issue, the NMPDES discussion, you mentioned that, that the proposal would affect both 20.6.2 and 20.6.4. Is the only place that 20.6.4 is affected by the permit system in the definition of wetlands, or are there other places?
Mr. Chair, 20.6.4 are the standards for our surface waters. So they have both numeric and narrative criteria that we implement into discharge permits. So 20.6.4 are the criteria we use to protect the designated uses. And then we implement those into a permit to ensure that that discharge does not adversely affect those aquatic resources or designated uses. So they work together in unison, but there are more places besides the general criteria. There's more than just the wetlands general criterion. We have a toxic narrative. We have a plant nutrients narrative criterion. We have a sediment narrative criterion. So there are other narrative criterions. And then we have the table in section 900 that has the numeric criteria for specific to designated uses. Those numerics are easy to translate into permits. So they work together to ensure that the discharge is not adversely affecting water quality.
Thank you. I understand the relationship between the two, but I haven't gone through 20.6.4 in detail, but the only substantive change I saw was in wetlands. But that's a question for other venues during the hearings, I suppose. Other questions from the commission? So again, this is a petition for a hearing, and or I would suggest that you allow me to appoint a hearing officer, but Ms. Orth has agreed to do that. So I would entertain a motion to approve the request. Commissioner, are there any public comments? Thank you. Mr. Sloan.
I'll give it a try. Move to set the matter of proposed amendments to 20.6.4 NMAC standards for interstate and intrastate surface waters, and to allow the chair to designate a hearing officer and set a schedule.
Commissioner Laney.
Second.
Okay, it's been moved in second. Is there further discussion? Hearing none, let's call the vote. All in favor of the motion, say aye. Aye. Opposed? Abstained? Thank you. Before we get into agenda item number 7, which is a hearing on Tijeras, Arroyo, let's take a 15-minute break and we'll reconvene at 25 minutes past the hour. Okay. We're going to reconvene the meeting a little bit later than I expected. This get my spectacles on. This is WQCC 25-28. It's a hearing on a proposed a revision of the designated uses of Tijeras, Arroyo. And I'm not sure who goes first, petitioner? Oh, I'm sorry. Yes, it's a public hearing. The hearing officer is Miss Felicia Orth. So thank you.
Yes, of course, Mr. Chair. Thank you very much. David, I see you on the platform. All righty. Good morning. My name is Felicia Orth, hearing officer appointed by the commission to conduct a hearing in WQCC 25-28. This is a petition to amend 20.6.4.97 of the New Mexico Administrative Code, modify the designated use of the Rio Grande to Four Hills Bridge reach of the Tijeras Arroyo. Petitioner is National Technology and Engineering Solutions of Sandia. The hearing will be conducted pursuant to 20.1.6 of the New Mexico Administrative Code. These are the Commission's rulemaking rules. Among other things, that means testimony is taken under oath and subject to cross-examination. The parties in this case include the petitioner, the Surface Water Bureau of the New Mexico Environment Department, and Mr. Maxwell also entered an appearance. Not sure if we have Mr. Maxwell on. We have one witness testifying for the petitioner, that's Mr. K. One witness testifying for the department, that's Ms. Barcolo. And then there are three more potential witnesses who might who will be available to answer potential questions. Following the technical testimony, I will invite a non-technical public comment. Following that, we'll close the record and the commission can choose to deliberate immediately. That was in the public notice and on the agenda, or you can choose to deliberate at a subsequent meeting. Let's have appearances from the petitioner, Mr. Molenberg, or yes, hi.
Good morning, Serafina Saluja on behalf of the petitioner, and I'm also joined by Dalva Molenberg and Constantine Parkamenko.
Thank you very much. Ms. Scott.
And Brecken Scott for the New Mexico Environment Department.
Thank you. And Mr. Maxwell, I see you on the platform. We cannot hear you.
Good morning, everybody. Can you hear me now?
Yes.
Hello.
Hello.
This is Nicholas Maxwell of Lee County. I've entered an appearance today. Thank you for having me.
Thank you very much, Mr. Maxwell. Ms. Saluja, would you like to make an opening statement, or are there any other preliminary matters we need to address? Okay. Ms. Scott, I think you were going to go first.
Yeah, that's okay.
Yes. Thank you.
I'll go first. Good morning, Madam Hearing Officer, Chair Thompson, and members of the Commission. Thank you for being here today. My name is Brecken Scott, and I represent the Surface Water Quality Bureau of the Water Protection Division of the New Mexico Environment Department. NMED is not the petitioner in this rulemaking, but the department is here today in support of petitioner's proposed amendments to the New Mexico Administrative Code, or the NMAC, which specifically changed the designation of an unclassified water of the state from intermittent to ephemeral by adding a specific reach to the list of waters under 20.6.4.97C NMAC. My goal in this opening statement is to briefly provide some regulatory context and help situate you in this proceeding, docketed as WQCC 25-28. The petitioner will address the substance of the proposed rule amendment. The Water Quality Control Commission, or the WQCC, is directed and required to adopt water quality standards for surface waters of the state under the New Mexico Water Quality Act. The Water Quality Act states that the standards shall at a minimum protect the public health or welfare, enhance the quality of water, and serve the purposes of the Act. Furthermore, the Act states that in making standards, the Commission shall give weight it deems appropriate to all facts and circumstances, including the use and value of the water for water supplies, propagation of fish and wildlife, recreational purposes, and agricultural, industrial, and other purposes. As I stated previously, the unclassified water at issue, the Rio Grande to Four Hills Bridge reach of the Tijeras Arroyo, is currently an unclassified water of the state and subject to New Mexico's intermittent water quality standards, rather than those water quality standards for perennial or ephemeral waters. The phrase unclassified waters of the state is defined as those surface waters of the state not identified in 20.6.4.101 through 20.6.4.899 NMAC. The NMAC defines ephemeral as follows. Ephemeral, when used to describe a surface water of the state, means the water body contains water briefly only in direct response to precipitation. Its bed is always above the water table of the adjacent region. The NMAC defines intermittent as follows. Intermittent, when used to describe a surface water of the state, means the water body contains water for extended periods only at certain times of the year, such as when it receives seasonal flow from springs or melting snow. The Federal Clean Water Act and associated regulations set the floor at attaining water quality to allow for fishable, swimmable uses. Federal regulations at 40 CFR section 131.10G requires a use attainability analysis if a change in existing use is sought because attainment is not feasible due to one of 6 factors, including that the natural, ephemeral, intermittent, or low flow conditions or water levels prevent the attainment of the use. Aligned with the Clean Water Act, the NMAC states, the removal or amendment of a designated use to a designated use with less stringent criteria can only be done through a use attainability analysis. Use attainability analysis means a scientific study conducted for the purpose of assessing the factors affecting the attainment of a use. Requirements for use attainability analyses are set out under 20.6.4.15 NMAC, including requirements under the federal regulations at 40 CFR Part 131. Following completion of a UAA, a rulemaking with the Commission would be required to change water quality standards or otherwise of a classified or unclassified water. In addition to the Water Quality Act and associated rules, any person who initiates a rulemaking shall follow the New Mexico State Rules Act and associated regulations regarding public participation. Between petitioner and NMED, we ensured all public input, public notice, and public comment requirements were met, which brings us to today's public hearing as the final step in the rulemaking process. NMED's technical witness will provide much more detail on what I just set out. NMED respectfully requests that the WQCC deliberate immediately following the close of the technical case. NMED further requests that a hearing officer report not be requested by the Commission in this matter. The parties anticipate circulating a statement of reasons and final order and a concise explanatory statement in the next few weeks should the WQCC adopt the proposed rule amendment. Thank you for your time and consideration in WQCC 2528.
Thank you, Ms. Scott. Ms. Saluga.
Good morning, Madam Hearing Officer, Chair Thompson, and members of the Commission. My name is Serafina Saluja, and I'm here on behalf of National Technology and Engineering Solutions of Sandia, which I will refer to as NTES or Sandia in these proceedings. Today marks the culmination of many years of work done by Sandia and the New Mexico Environment Department in supporting the proposed amendment to 20.6.4.97 and MAC for the Tijeras Arroyo reach from the Rio Grande to the Four Hills Bridge. I will first give a brief overview of the legal background. Under the Federal Clean Water Act, every state is responsible for reviewing and revising its water quality standards. The regulations at 40 CFR 131.4 and 131.10 make clear that states must identify the appropriate uses for their waters and ensure that those uses are supported by protective criteria. When a state seeks to designate a use that is less stringent than a previously applicable use, it must conduct a use attainability analysis, or UAA, under 40 CFR 131.10. New Mexico's Water Quality Act mirrors this federal structure. Section 74-6-4D requires the Commission to adopt water quality standards for surface and groundwater based on credible scientific data, including accurate designated uses and the criteria needed to protect those uses. Importantly, the Commission may remove a designated use if a UAA demonstrates that the use is not feasible due to one of the factors identified in 40 CFR 131.10. That process is detailed in 20.6.4.15 NMAC, which also allows any person to submit a notice of intent to conduct a UAA. In addition, under Section 74-6-6B, any person may petition the Commission to amend a water quality standard. With that legal context in place, I will now turn to the basis for this petition. You are going to hear testimony today from John Kay, who is the program lead for stormwater permitting and compliance at Sandia. Mr. Kay will testify that the New Mexico Environment Department approved the UAA work plan, and the UAA was conducted in full compliance with the federal and state requirements I just outlined. The Tijeras Arroyo reach at issue was originally assessed by the department in 2009 using the hydrology protocol, which found the reach to be ephemeral. Because ephemeral waters may only have their non-existing designated uses changed through a full UAA, NTES developed a work plan and submitted it to the department in June 2017. After revisions, the department approved the plan in February 2018. The approved work plan focused on the second feasibility factor under 40 CFR 131.10, whether natural, ephemeral, or low flow conditions prevent attainment of the current designated uses. NTES conducted stream channel surveys in 2019 using the department's own hydrology protocol methods. Although the department later required the use of a full UAA process rather than the expedited pathway originally approved, the substantive scientific methods remained unchanged. The final work plan was approved in March 2023. You will hear that the UAA results are clear. This reach of Tijeras Arroyo is an ephemeral water body, a system that flows only in response to precipitation events and cannot support beneficial uses associated with intermittent streams. The highest attainable uses are limited aquatic life and secondary contact, not the currently designated marginal warm water, aquatic life, and primary contact. You will also hear that public notice and involvement occurred as required by law. NTES issued public notice on February 8, 2025, opened a 60-day comment period, published the draft UAA report, and hosted a public meeting. Multiple comment submission options were offered. No public comments were received, and therefore no revisions to the UAA report occurred. In summary, this petition is fully supported by the governing legal structure, by department-approved scientific methodology, and by an extensive, transparent public involvement process. The evidence will demonstrate that the currently designated use for this reach of the Tijeras Arroyo is not attainable, and that the highest attainable use is ephemeral water. For these reasons, we respectfully request that the Commission amend the water quality standards in 20.6.4.97 NMAC to include the Rio Grande to Four Hills Bridge reach of the Tijeras Arroyo. Thank you.
Thank you, Ms. Luja. Would you like to call your witness?
Yes, I'm going to call Mr. John Kay.
Mr. Kay, if you would please spell your first and last name.
Chairman, Commissioners, my first name is John, John, and last name is Kay.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. And if you'll be reading especially, please make sure to keep it slow.
Mr. Kay, where are you currently employed?
I work for National Technology and Engineering Solutions of Sandia. And I'll abbreviate that as NTES here on it.
What role do you hold at NTES?
I am the program lead for the stormwater quality permitting and compliance.
And how long have you served in this role?
It'll be 11 years in January.
Is NTES Exhibit 1 a copy of your resume?
It is.
Is NTES Exhibit 2 a copy of your written narrative testimony?
Yes, it is.
Do you have any corrections to your resume or written testimony?
I don't have any corrections, but I just wanted to clarify. I used the term classification in my written testimony, and I meant that in a colloquial sense. I just wanted to reiterate that we're petitioning for a change in designated use.
Do you adopt under oath today NTES Exhibit 2 as your testimony?
Yes, I do.
Have you prepared a summary of that testimony to share with the commission today?
Yes.
Please go ahead and share your summary.
Good morning. My name is John Kay, and I'm the program lead for stormwater permitting and compliance at NTES, the contractor that operates Sandia National Laboratories in New Mexico for the Department of Energy's National Nuclear Security Administration. Between 2018 and 2023, NTES conducted a comprehensive use attainability analysis, or UAA, for the Rio Grande, the Four Hills Bridge reach of Tijeras Arroyo. The purpose of this analysis was to determine whether this reach functions as it is currently classified, an intermittent stream, or whether it is more accurately characterized as an ephemeral water body under New Mexico Administrative Code 20.6.4.97. A UAA is required under 20.6.4.15a NMAC and 40 CFR 131.10 anytime a change in designated use would result in less stringent water quality criteria. A UAA must evaluate existing uses, determine whether the existing designated use is truly attainable, and identify the highest attainable use if the current use cannot be met. I would draw your attention to the screen where I'm showing two maps. The map on the left-hand side is just a location map of the subject reach. It's outlined in blue. It extends just north of the area in the black and white hash marks is Kirtland Air Force Base, where Sandia National Laboratories is located. And the map on the right shows the lighter shaded area is the Tijeras Arroyo watershed. That's where water comes from that drains to Tijeras Arroyo. There's two reaches delineated. The lower reach, which is shown in green, is the subject reach. That's the Rio Grande to Four Hills Bridge reach that we're talking about today. The reach in red is the Four Hills Bridge to Headwaters reach, which is generally acknowledged to contain intermittent and perennial flows, and we're not dealing with that reach. Our UAA focused on factor 2 under 40 CFR 131.10G, which applies where natural, ephemeral, intermittent, or low flow conditions prevent attainment of the designated use. To make this determination, we evaluated hydrology, geomorphology, biology, vegetation, soils, and land use conditions throughout the reach and the contributing watershed. If we can go to slide 4. This is just reiterating what I just said, but I've highlighted in red the reasons that we believe that the designated uses of intermittent waters can't be attained. The findings of the UAA were consistent across all lines of evidence. The only sources of flow in the reach are direct stormwater runoff from isolated precipitation events and small, irregular, non-stormwater discharges from municipal activities. These non-stormwater discharges occur infrequently in small volumes and infiltrate rapidly. They very rarely generate measurable flow and essentially never reach the Rio Grande. We documented no fish, no macroinvertebrates, no algae communities, no springs or seeps, no hydric soils, and no iron oxidizing bacteria. Vegetation within and adjacent to the channel mirrors upland vegetation rather than riparian communities, and no riparian zones were present. Geomorphic features such as channel form, substrate sorting, floodplain characteristics, and sinuosity were all consistent with ephemeral streams. Hydrology protocol scores for individual subreaches ranged from 4 to 8, with an average score of 6.1. Under the hydrology protocol guidance, scores below 9 are indicative of ephemeral conditions. These findings do not meet the regulatory definition of intermittent, which requires the presence of water for extended periods during certain times of the year, typically due to seasonal groundwater or snowmelt contributions. They do, however, meet the definition of ephemeral, a water body that flows only in direct response to precipitation, with its bed lying above the regional water table. I've provided the verbiage from 20.6.4.7 NMAC of the definitions of intermittent and ephemeral. As a result, the designated uses of primary human contact and marginal warm water aquatic life associated with intermittent waters are not attainable for the reach. The highest attainable uses were determined to be limited aquatic life, and secondary human contact, which are associated with ephemeral waters. The table shows the designated uses associated with intermittent and ephemeral waters with a description of each. And the two that I just mentioned, the aquatic life and human contact designated uses, are the ones that cannot be attained for intermittent classification. Based on these results, the UAA recommends reclassifying the Rio Grande to Four Hills Bridge reach from intermittent to ephemeral. NTAS is not seeking any new discharges, increases in stormwater volume, or operational changes of any kind. Our sole interest is ensuring that the regulatory designation accurately reflects the hydrologic reality of the reach so that we can comply with water quality standards in a scientifically appropriate manner. NTAS also conducted public outreach as required. We issued a 60-day public notice from February 8 through April 10 of 2025, accepted comments through multiple platforms, and hosted a public meeting on March 5th, 2025 in Albuquerque. UAA documents were made available through the University of New Mexico Digital Repository. There were no public comments submitted during the comment period. We also directly contacted a broad range of stakeholders, including the Pueblo of Isleta, Kirtland Air Force Base, the Albuquerque Metropolitan Area Flood Control Authority, Bernalillo County, the City of Albuquerque, the U.S. Geological Survey, U.S. Fish and Wildlife Service, U.S. EPA, local conservation groups, neighborhood associations, and state agencies. All stakeholders were offered meetings and provided with the full UAA. No stakeholder requested a meeting or expressed concerns. In closing, the multi-year UAA conducted by NTES demonstrates that the Rio Grande to Four Hills Bridge reach of Tijeras Arroyo meets the definition of an ephemeral water body under the applicable state regulations. Natural hydrologic and geologic conditions prevent attainment of uses associated with an intermittent classification, and the evidence supports updating the designated use to reflect the highest attainable use. NTES therefore petitioned the Commission on June 6, 2025 to amend 20.6.4.97 NMAC accordingly. And I'd just like to show a few pictures of the reach. These show, when we did our study, we subdivided the reach into 8 subreaches. These are sub-reaches 2 and 3, which are located downstream of Kirtland Air Force Base and just upstream of Interstate 25. These are sub-reaches 4 and 6, which are located within Kirtland Air Force Base. And these are sub-reaches 7 and 8, which are located upstream of Kirtland Air Force Base. And I just showed these pictures to make the point that it's a very ephemeral stream. This concludes my testimony. Thank you for your time and consideration, and I'm open to answer any questions that you may have.
Thank you very much, Mr. K. Ms. Scott, do you have questions of Mr. K? You said no. Mr. Maxwell, do you have questions of Mr. K?
I have just a few questions.
All right.
Hello, my name is Nick Maxwell. I'm a member of the public here in the state. Good to see you today, Mr. K. I have a question about the public notice. Was it your testimony today that the public notice met all of the requirements of the State Rules Act?
Yes, to the best of my knowledge.
Are you aware that the State Rules Act requires a citation to the technical information that is used in the rulemaking?
I don't know that I'm familiar with that.
And I would just like to see if, given, would you assume that there is a requirement that technical, I'm sorry, would you assume that there is a requirement for a citation to technical information to be included in the public notice?
I don't know if that's required or not.
Thanks. That's all my questions.
All right. Thank you, Mr. Maxwell. Commissioners, do you have questions of Mr. K? We'll start on this side. Mr. Brankford?
Just one question. The map you showed of the stream segment indicated that there were tributaries to that segment, including, I think one was named Arroyo del Coyote.
Arroyo del Coyote. There are Arroyo del Coyote would be the only what I would consider to be a tributary or a stream. Everything else that flows in is more of a gully. But Arroyo del Coyote similarly exhibits ephemeral characteristics and only flows in direct response to precipitation for short periods of time.
So would this rulemaking also classify tributaries of this segment as ephemeral, or would they remain intermittent?
The way I want to answer that question, and there's people that understand the regulations better than I do, but Arroyo del Coyote does not appear in the 303D list. And so it's really, I don't know that it's classified as anything.
Is that all, Commissioner Brankford?
Yes.
Okay. Commissioner Bayless, do you have questions? No? Commissioner Sloan?
I think I just have a couple. Sort of in a broader sense, why is it important for Sandia to change the designation?
Yeah, that's a good question. If we had known 8 years ago that it was going to take as much time and effort as it did, we probably wouldn't have pursued the effort. It started as really a housekeeping effort to align the regulations with what we feel the hydrologic conditions are. And there is a comment in the 303D list that was Ms. Scott mentioned. NMED had assessed the reach and found it to be ephemeral, and we contacted them and asked what the status of getting that changed was, and we were told that they didn't have the resources or the ability to do that, but if we wanted to do some of the footwork, that they would support that effort. And we thought it would be a quick effort. It turned out not to be, but to answer your specific question, we really gain nothing practical from this other than we have multiple environmental reports that we publish every year, and we'd like to be able to refer to Tijeras Arroyo as ephemeral without contradicting what it's called in the regulations. But yeah, there is no immediate or foreseen benefit to us in terms of, you know, regulatory obligations or criteria that we have to meet.
Following up on that, does the change of designation change the sort of the standards that apply, or?
It does. The only ones that are relevant to what we're required to monitor for are metals water quality standards, and it would change the water quality standard from from chronic standards to acute standards, which would raise the water quality standards a little bit. However, we're currently underneath the more stringent chronic water quality standards, so we don't get a benefit from that.
Thank you.
All right, Mr. Chair.
This is a little bit beyond the scope of the use attainability analysis, but we heard in one of the previous agenda items talking about dredge and fill program, and as you know, the Tijeras Arroyo's got a lot of erosion. It's going to require drop structures or grade control structures, probably some type of bank stabilization. By reclassifying this as ephemeral instead of intermittent, will that the new proposed dredge and fill regulations affect your ability to stabilize that channel?
Mr. Chair, I don't think I can answer that question because our focus was really on the water quality side and not the dredge and fill. I would, yeah, I'll just leave it.
That's fine. That's the type of question I think that's going to come up next summer, and you know, that as you know better than I, that channel is a mess with a large sewer line that runs along the basin that needs protection. So it would be helpful if next summer you guys could participate and give us some thoughts about it. Thank you. I have no questions.
Thank you, Vice Chair Zemek. Okay, Commissioner Chapman. All right, Commissioner Fry.
No questions.
All right, Commissioner Laney.
No worries. My questions have been satisfied. Thank you.
All right, thank you, Commissioner Langer.
No questions.
All right. Do you have any follow-up, Ms. Saluha?
No follow-up, although I would like to offer his exhibits at this time.
All righty. Are there objections to petitioner's exhibits? I'll pause for a moment. Okay, they're admitted. Thank you very much. And as to the public notice question posed by Mr. Maxwell, I can certainly ask the department if they have anything to add to what Mr. Kay said. Failing that, we might have to take a break so that we can track that down. Oh, Mr. Sloan, Commissioner Sloan.
I'm a hearing officer. I noticed in the New Mexico Water Quality Control notice of public rulemaking hearing that there is a following. Proposed regulations and supporting information may be reviewed on any URL. Technical information that served as a basis for the proposed rule may be obtained from the petitioners on request.
All right, thank you for that, Commissioner Sloan. Thank you, Ms. Saluja and Mr. Kay. We'll turn now to the department.
I'd like to call NMED's technical witness, Stephanie Clark Barkalow.
Thank you very much, Ms. Scott. Ms. Barkalow, would you spell your first and last name, please?
Madam Hearing Officer, Chair Thompson, members of the commission. First name is Stephanie, S-T-E-P-H-A-N-I. And last name is Clark Barkalow, C-L-A-R-K space B-A-R-K-A-L-O-W.
Do you swear or affirm to tell the truth?
I do.
Thank you very much, and just keep it slow.
Ms. Clark Barkalow, where are you employed?
I work for the New Mexico Environment Department.
And how long have you worked for NMED?
I've worked for NMED since April of 2025 with the Surface Water Quality Bureau.
And what's your current role?
I am part of the Monitoring, Assessment, and Standards section and serve as a Senior Water Quality Standards Scientist.
What are your current job duties?
In this position, I'm responsible for the development, review, revision, and maintenance of surface water quality standards.
And please describe your educational qualifications.
I have a Bachelor of Science in Biology, the minor in Environmental Science from University of New Mexico, and a Master of Science in Fisheries Conservation and Management from University of Arizona.
Did you submit a copy of your resume as NMED Exhibit 2?
Yes.
Did you submit written direct testimony as NMED Exhibit 1?
Yes.
And did you submit any written rebuttal testimony in this?
No.
Do you have any corrections or changes to your direct written testimony?
My only change would be to clarify references I made in my written direct testimony to the reach being classified or having a classification of intermittent. I did not mean to convey that the section at issue today is a classified water of the state. The section is unclassified and would remain unclassified if the commission adopts the petitioner's proposed amendments.
Do you adopt the remainder of your written testimony?
Yes.
Can you provide a summary of your testimony, starting with providing some regulatory context?
Slow down.
My testimony will provide background on the framework for water quality standards, including designated uses and criteria, outline the administrative processes and procedures for standards amendments, and describe our collaboration and coordination efforts with the petitioner to review their technical work, propose regulatory language, stakeholder engagement plans, and to provide public notice of the rulemaking hearing on behalf of the Commission. State and federal statutes and regulations outline the requirements and regulatory framework for water quality standards and authorize states to adopt standards to protect public health or welfare, enhance water quality, and serve the purposes of the laws. The goal of the Federal Clean Water Act, as stated in Section 101A2, is to provide, wherever attainable, for the protection and propagation of fish, shellfish, and wildlife, and for recreation in and on the water. These are generally referred to as fishable, swimmable uses. Federal regulations direct states to set designated uses and criteria to protect those uses consistent with this goal. New Mexico's water quality standards, as codified at 20.6.4 NMAC, and the designated uses set forth in Section 900 include fish culture, public water supply, industrial water supply, domestic water supply, irrigation and irrigation storage, primary and secondary contact, livestock watering, wildlife habitat, and aquatic life. The standards establish water quality criteria that protect the designated uses of a water body. These criteria can be general narrative criteria that apply to all waters, or numeric criteria that apply to a specific designated use or water quality segment. New Mexico's water quality standards include criteria applicable to all surface waters with designated, existing, or attainable aquatic life and recreational uses. This includes narrative criteria and acute and chronic numeric criteria.
Can you now please summarize your testimony regarding designated uses and unclassified waters?
Federal regulations allow for states to adopt subcategories of designated uses to refine and clarify specific fishable, swimmable use classes. New Mexico has adopted 7 subcategories of aquatic life use, including cold water, cool water, and warm water aquatic life uses that have specific criteria for temperature, dissolved oxygen, and pH, in addition to the narrative and numeric criteria that apply to all aquatic life uses. New Mexico has adopted 2 subcategories of recreational use, primary and secondary contact, that have specific criteria for E. coli. Primary contact also has criteria for cylindrospermopsin and pH. Unclassified waters are those waters for which the Commission has not adopted a segment description. Unclassified waters are subject to designated uses and applicable water quality criteria of 20.6.4.98 NMAC if intermittent and 20.6.4.99 NMAC if perennial. The section of Tijeras Arroyo from Rio Grande to Four Hills Bridge is currently protected as intermittent under Section 98 of the standards, with marginal warm water aquatic life use and primary contact recreational use. This Tijeras Arroyo assessment unit is listed in the 2024-2026 integrated report with a category assessment of 3/3A, indicating that insufficient information is available to determine if designated or existing uses are being attained. NMED conducted the hydrology protocol in 2009, which indicated that this assessment unit is ephemeral. However, the Commission may only include an unclassified water of the state under ephemeral waters following a use attainability analysis, or UAA.
Can you please summarize the use attainability analysis process and requirements?
A UAA is required for revising the fishable, swimmable uses under Clean Water Act, Section 101A2, when removing the designated use or revising the designated use to include less stringent criteria. A UAA uses scientifically defensible methods to assess the factors, including natural conditions, affecting the attainment of the designated use. UAAs that conclude a designated use should be reviewed, revised, or removed must also determine the highest attainable use that is closest to Clean Water Act, Section 101A2, fishable, swimmable use, based on the factors evaluated in its study. Third-party UAAs require the person conducting the UAA to develop a work plan that outlines the water body and reasoning for the UAA, the source of the data to be used to demonstrate the current designated use is not attainable, the 40 CFR 131.10G factor to be evaluated, the data to be used to determine the highest attainable use, the state and federal agencies to be consulted, the stakeholder engagement and outreach process, the public notification process to be used, and the expected timeline, including any rulemaking activities that result from the UAA. Once a work plan is reviewed and approved by NMED and EPA, the UAA may be conducted. Upon completion of the UAA, the data and findings are then submitted to NMED and public notice is provided to stakeholders in accordance with the work plan. If the UAA concludes that an amendment to designated uses and criteria is appropriate, NMED or the third-party petitioner may initiate the rulemaking process.
Can you now provide a summary of your testimony as it relates to the process of amending water quality standards through a rulemaking?
Rulemaking before the Commission begins when a person files a written petition and statement of reasons to adopt, amend, or repeal a regulation in accordance with 20.1.6.200 NMAC. The water quality standards allow any person to petition the Commission to adopt, amend, or repeal a water quality standard, including designated uses. The petition must also identify the specific waters to which the amendment would apply, explain the rationale for proposing the amendment, describe the stakeholder engagement process, present and respond to the public input received, and present the scientific findings of the UAA and derivation of the proposed criteria. If the Commission grants a hearing, notice of the rulemaking must be provided to the public in accordance with state statutes and regulations. The agency must distribute rulemaking information and provide public notice by publishing in a newspaper of general circulation and the New Mexico Register, posting information on agency websites, and contacting interested and affected parties. The public notice of rulemaking must include the subject, the summary, and the purpose of the proposed rule, the legal authority for the rule and its adoption, the technical basis for the proposed rule and how to find technical information, governing laws of procedure, and how to present information and participate in the hearing, examine documents, and download information. In addition to publishing, the Commission must provide to the public notice of rulemaking by distributing information by posting it on the Commission's website, posting it on the New Mexico Sunshine Portal, making it available at the applicable constituent agency's district, field, and regional offices, sending it by email to people who have made a written request for notice of announcements addressing the subject of the rulemaking proceeding, and who have provided an email address to the Commission administrator, sending it by email to people who have participated in the rulemaking and who have provided an email address to the Commission administrator, sending written notice that includes, at a minimum, an internet and street address where the information may be found to people who provide a postal address, and providing it to the New Mexico Legislative Council services for distribution to appropriate interim and standing legislative committees. If the Commission adopts new or revised standards at a public hearing, NMED submits those standards to EPA for review and approval.
And finally, can you summarize the department's coordination with the petitioner and the department's compliance with public notice requirements?
NMED worked with the petitioner to discuss expectations, develop a common understanding of requirements, and coordinate timelines and resources. As a result, the petitioner developed a work plan that included technical analysis, stakeholder outreach and engagement, and consultation with state and federal government agencies. NMED reviewed and approved the work plan February 9th, 2018. NMED and EPA provided feedback and comments throughout the planning and development of the UAA. Based on this early engagement, an initial draft UAA was developed and submitted to NMED for review June 8, 2020. After the petitioner completed the UAA, amendments were made to the use attainability analysis section of the standards at 20.6.4.15 NMAC to clarify the requirements of an expedited UAA using the hydrology protocol. As a result, the petitioner produced a revised UAA work plan, which was approved by NMED on March 8, 2023. NMED submitted formal comments on the second draft of the UAA on April 3, 2023. The petitioner addressed comments and revised the UAA in a report dated June 8, 2023. The petitioner held a stakeholder meeting and 60-day public comment period that ended April 10, 2025, but did not receive any comments. Throughout the process, the petitioner solicited input from NMED, EPA, stakeholders, and the general public, and responded to all input, feedback, and comments they received in their final UAA provided with their petition. The public notice for the hearing was drafted and published by the petitioner in the Albuquerque Journal and in the New Mexico Register. NMED assisted the petitioner and commission with notification requirements and provided rulemaking information to the public by posting the notice of rulemaking and information to the Commission's website, the New Mexico Sunshine Portal, at NMED's district and field offices, and by sending emails with the public notice of rulemaking to the Office of Public Facilitations and Surface Water Quality Bureau's listserv subscribers, to the Legislative Council Service, and the Small Business Regulatory Advisory Council. Additionally, NMED posted the public notice and rulemaking information on its event calendar, the Surface Water Quality Bureau's website, the NMED Public Notice website, and created an entry on NMED's public comment portal. All provide to public requirements were completed for the first scheduled hearing by August 14th, 2025. The rulemaking was rescheduled to allow for publication of the public notice in both English and Spanish in the Albuquerque Journal and the New Mexico Register, so NMED completed all provide to public requirements by October 10th, 2025. In conclusion, Commission regulations allow for the revision of designated uses and inclusion of an unclassified water of the state under ephemeral waters when supported by scientifically defensible methods. NMED and the petitioner worked collaboratively on a work plan, and NMED considers the petitioner to have followed the work plan to develop and revise a UAA, complete stakeholder engagement activities, and respond to public comment throughout the process. The proposed revisions are based on scientifically sound approaches and methodologies, and NMED considers the petitioner to have properly complied with the provisions of 20.6.4.10 NMAC and 20.6.4.15 NMAC. The UAA demonstrated that naturally occurring hydrologic conditions prevent the attainment of fishable, swimmable designated uses applicable to intermittent waters. NMED recommends that the Commission adopt the proposed amendments to include this section of Tijeras Arroyo with ephemeral waters under 20.6.4.97 NMAC. If the Commission so adopts the proposed amendments, the Surface Water Quality Bureau would submit the revised water quality standards as published by the State Record Center and Archives in the New Mexico Register to EPA for formal review and final approval action under Section 303C of the Clean Water Act.
Ms. Clark-Barklow is available for questions.
Thank you, Ms. Scott and Ms. Clark-Barklow. Ms. Lujan, do you have questions of the witness? No. Mr. Maxwell, do you have questions of the witness?
No questions.
Thank you. Let me start with the commission. I'll start with Commissioner Langer.
No.
Commissioner Laney.
I have no questions.
All right. Commissioner Fry.
No questions.
Commissioner Chapman.
No questions.
Vice Chair Zenlik.
No questions.
Chair Thompson.
No questions.
Commissioner Sloan.
No question.
Commissioner Bayless.
No question.
Commissioner Brinkard.
Someone needs to ask a question. I'll just repeat the question I had from the other witness, which is that what appears on the map shown by the Sandia witness, that there was at least one, what appears to be a tributary of the Arroyo del Coyote. Is that in any way affected by this proceeding?
No, that tributary would remain unclassified and subject to 20.6.4.98, which is the intermittent waters, until otherwise evaluated.
Thank you.
Okay. Any follow-up, Ms. Scott?
No follow-up. And I'd like to move for admission of all of NMED's exhibits.
All right, I'll pause for a moment in the event there are objections. All right, the NMED.
I have a question. I'm sorry.
Chair.
And again, this is only peripheral. I have a vague recollection back in the deep recesses of my mind that there was a separate category for waters that were on properties owned by Department of Defense organizations. And so my question, I guess, is twofold. First of all, is all of Tijeras Arroyo not owned? Is any of Tijeras Arroyo owned by Department of Defense as opposed to Department of Energy? And then the second question is, if it is owned by Department of Defense, are there any special criteria or regulations that pertain to that?
I'd want to call an additional NMED witness to answer this question.
All right, who are you calling, Ms. Scott?
I'll call Lynette Guevara, or yep. Okay, Lynette Guevara.
Alrighty. Ms. Guevara, would you please spell your first and last name?
Sure. My first name is Lynette, Lynnette. My second name is Guevara. My last name is Guevara. G as in George, U-E, V as in Victor, A-R-A.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. Go ahead, Ms. Scott.
And Ms. Guevara, where are you employed?
I'm employed at the Environment Department Surface Water Quality Bureau.
How long have you worked for NMED?
Oh, geez. I've worked for NMED for 24 years.
And what's your current role?
I am the program manager of the Monitoring, Assessment, and Standards section.
And your current job duties?
As program manager, I manage a team of 3 separate groups: the monitoring group, the TMDL and assessment group, and the water quality standards and outreach group.
And did you submit a copy of your resume as NMED Exhibit 4 in this matter?
Yes, I did.
And did you submit any written testimony in this matter?
I did not.
Okay, so.
Again, my question is any of the subject reach owned by Department of Defense? And if so, are there special provisions regarding its protection?
Chair Thompson, the subject reach Tijeras Arroyo from the Rio Grande to Fort Hills Bridge does contain portions that are managed by the Department of Energy, but there are no specific, it's not called out in 20.6.4 NMAC in any way. You might be thinking of 126 and 128 where it makes specific reference to DOE managed lands, but that is not the case in this scenario.
Okay, thank you.
Okay, anything further from the commission? Ms. Scott?
I don't have any follow-up, but I just want to make sure, just to be really clear, that our all of our exhibits were admitted, including.
I admitted all exhibits,
Okay.
yes. Let me note before you leave the dais there that Mr. Maxwell has submitted a written comment, written public comment following up on his question of Mr. K earlier regarding the failure of a citation to the technical information in the notice, and I'm wondering if perhaps we could take just a short break. You could look at his comment, and then we can proceed to, for example, a closing statement, and in the event the commission chooses, deliberations. All right. Before we break, though, Mr. Maxwell, I do have your written comment here. Do you have anything to add?
I don't at this time. Thank you.
All right, thank you. Let's take 10 minutes and come back at 11:40. How about that? Almost 15. All right, we are back after a break. Ms. Saluha, do you have something to add here?
Yes, I think the best course forward would be to call Mr. K and to do a brief redirect.
Thank you. Mr. K? You are still under oath.
I have a few follow-up questions for you. Does the UAA contain all the technical information to support the basis of the rule amendment?
Yes, it does.
And was the UAA attached to NTES's petition in this matter?
Yes, it was.
And was the link to find the UAA and associated information provided in the public notice, which also included a link to the commission docket matter page where the petition and UAA are available?
Yes, it was.
And finally, did anyone request any additional technical information?
We received no request.
All right, thank you, Ms. Saluja and Mr. K. Ms. Scott, do you have questions about that? Mr. Maxwell, any questions about that little bit?
No questions.
Thank you. Does any commissioner have a question? Just raise your hand. Commissioner Brankard.
Well, I guess I was just looking at the petition a minute ago, and there's no UAA attached to it.
Yeah, so it's the link to the Docketed Matters website where it can be obtained.
Well, I guess I think this notice is fine the way it was done, but I think, you know, if you're going to have something in a notice that says contact the petitioner, there ought to be a contact, a website, an email address, etc. I mean, it would have been, and particularly since the department had its own website with the UAA on it, would have been really easy to put that in the notice. And I'm just sort of saying this because we're heading into more big technical rulemakings coming up here. So we, you know, that is a requirement of the Rules Act that we have to have a way for people to access the technical information that's the basis of the rulemaking. So addressing not just you, but also members of the department in going forward here.
Thank you, Commissioner Brankard. Other commission questions? Chair Thompson.
I have a question. So the UAA was submitted as part of your technical testimony.
Correct.
As
Yes.
Exhibit 3, and so I'm a little bit uncertain what Commissioner Brankard's objection is.
Okay. At the time the notice went out, if you link to the Docketed Matters, you wouldn't necessarily find the UAA at that point. It would appear soon thereafter with their testimony.
Okay, thank you. I appreciate it.
Other commission question? No? All right. Anything further from anyone? No? All right. Thank you very much, Ms. Saluja, Mr. K. Is there any reason not to close the evidentiary record at this time? All right, the record is closed, and Mr. Chair, the floor is yours.
Thank you. Thank you for all the participants. I appreciate your brevity and clarity. So at this point, what's the pleasure of the commission? Do we want any further discussion, or are we ready to take action on this petition, this request? Hearing none, my sense is, certainly my opinion is that we're ready to take action, and I would entertain a motion. Again, my preference would be that we accept the petition, but I would entertain a motion. Commissioner Sloan.
Mr. Chair, Commissioner Brankard, I move that the commission adopt proposed amendments to 20.6.4 NMAC as set forth in the petition in case 2528.
This is Commissioner File, second.
Thank you. So it's been moved and seconded to adopt petition to change the designated use of Tijeras Arroyo. Is there further discussion? We ready to vote? Does this need to be a roll call vote, or can we just do a voice voting? It's been suggested that we do a roll call vote.
Mr. Chair, before we off it, just from procedural kind of stuff.
Speaking, please.
Mike Sloan, Commissioner Mike Sloan.
Thank you,
So
sir.
I guess I have a question regarding sort of the procedure here, because I haven't done this in a long time. There's the usually when we do this, the state stuff. So will we say we approve this now? Will we then have to approve those documents later? Curious about the procedure.
Commissioner Sloan, I believe Ms. Scott said earlier that they would prepare the statement of reasons, circulate those within 2 weeks, and those can be adopted by the commission at a subsequent meeting.
Or the chair can also sign those statement of reasons if he has no edits to them.
I think that goes to your question, Commissioner Sloan. If in fact you want to authorize the chair to sign the statement of reasons when they're prepared without coming back at a subsequent meeting, that would be okay too.
Presumably that would have to be part of the original motion.
Okay, so what I think I heard was we're requesting the person that moved it to just add this statement that the chair would have the authority to approve the statement of reasons. Is that correct?
Mr. Chair, this is Commissioner Brancard. I'll amend my motion then to authorize chair to review any proposed statement of reasons from the party, and you can either approve it or decide that the full commission should approve it.
Okay. And the person who seconded the motion, you agree?
Yes.
Thank you. It's fairly common that the statement of reasons is approval is given to the department chair unless it's very controversial. Okay, are we ready to vote? So this will be a roll call vote. Ms. Jones, could you call the roll, please?
Commissioner Zemlik, how do you vote?
Yes.
Commissioner Bayless,
Yes.
Commissioner Brancard,
Yes.
Commissioner Chapman,
Yes.
Commissioner Langer,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams.
Yes.
Thank you. Commissioner Rosatos. Oh, he dropped off. Commissioner Sloan,
Yes.
Chair Thompson,
Yes.
and Commissioner Laney.
Yes.
Chair Thompson, the motion passes.
Okay, thank you. I think we did good work today. Next thing on the agenda is our next meeting, which will be in January, and I don't have the date. I assume that'll be the second Tuesday.
Yes, the next meeting is January 13th. And we have one agenda item at this point is 2567, the hearing, the Protecta Suque BL Santa Fe matter.
Yes.
Commissioner Branker will sit as hearing officer.
Okay. So that will be our next meeting. We'll see if there are any other agenda items. Any further discussion about anything for the commission? You ready to adjourn? I didn't entertain a motion to adjourn. So moved. Okay, we're adjourned. Thank you.